गीता जी आप स्टार्ट कीजिए।
Good good afternoon, everyone. Once again, I would like to welcome you all in today's series of our marathon. It is our 37th series, and I am honored to introduce with today's panelist, our guest speaker, CA Advocate Aseem Chawla ji, our session chairman. He has yet to join, Shri R.P. Garg, former Senior Vice President ITAP, our session moderator, CA Sunil Garg, and we have with us a co-panelist, Shikha Bharadwaj, who will join in a while with us. So today's topic is taxation of digital economy with an emphasis on the scheme of equalization levy, international taxation. Today we will discuss about the topics covered background and Indian tax policy development relatable to e-commerce transactions, online information database access and retrieval service, salient features of equalization levy, scheme of deduction of tax at source under section 194O of Income Tax Act 1961. I am honored to introduce our today's guest speaker, CA Aseem Chawla ji. Aseem Chawla ji is a practice leader at ASM Legal Solicitors and Advocates in New Delhi. Aseem is a member of Bar Council of India and fellow chartered accountant and certificate holder of comparative tax policy and administration from Harvard Kennedy School. He is a candidate for the prestigious Yana certificate in double tax treaties under the auspices of W. Vienna University of Economics and Business, Austria. He is a certificate holder from National Insurance Academy, Pune, for participation in the orientation program for independent directors for general insurance companies in February 2020. Aseem has extensive experience in advising on a variety of tax matters, including international tax, inbound and outbound investment, structuring, and cross-border tax issues, corporate and business advisory, exchange control, and regulatory and money laundering laws. He is an accredited trust and estate practitioner and member of Society of Trust and Estate Practitioner (SGEP) UK. Aseem is well regarded as estate planning, inheritance and family governance, trust and private clients, including national and international clients, high net worth individuals, and trusted and family offices. Aseem is also visiting associate professor with an Institute of Chartered Accountants of India on economic offences and money laundering laws. He is regularly invited to address various domestic and international forums and industry bodies. He is actively involved in leadership capacities of various professional association and industry chambers. He is the vice chair of the South Asia, Oceania and Indian Committee section of International Law and is an officer ABA International Tax Committee. He is the outgoing secretary of the Tax Committee of the International Bar Association and vice chair of the Task Force of Legal Services of the Confederation of Indian Industry. He is the chairman of the Financial Services and Taxation Committee of the Indo-American Chamber of Commerce. He is consistently adjudged over the years as one of the leading tax experts in the Asia Pacific region. He is identified among 40 leading Indian lawyers under 45, and his name finds mention in 100 Legal Luminaries of India, published by LexisNexis. His views are often sought on contemporary tax and policy matters by the print and electronic media. He has also several authorships to his credit. Asian Law Profiles 2019 and its clients' feedback on individual lawyers' comments. Aseem Chawla is very well versed with the subject knowledge and highly networked, working with rational and logic and great communication and coordination skills. Chamber and Partners claims Aseem Chawla leads the tax efforts at ASC legal solicitors and advocates and is known for his robust advisory practice, and he advises major companies on international and cross-border tax matters. One peer praises him as an innovator who has provides creative solutions to his clients. Further, Mr. Chawla has tremendous knowledge and expertise in scrutinized, advanced and complex legal text matters with foresight, and as both very knowledgeable and analytical, and a pleasure to deal with. Recognized by peers as an experienced practitioner who is highly active in tax litigation. Chambers Asia Pacific Guidepost are seen as a text encyclopedia, as stated by a client, while another client knows that he is highly focused with very good knowledge. He takes a 360-degree perspective on things, which also having an eye for detail. He gives long-term advice, which is important and helps to position ourselves strategically. He is prompt, available all the times, and has been consistently accurate in his assessment on the merits and the predictions of the court action. Aseem is nominated by Ministry of Finance, Government of India as non-executive independent director on board of one of the largest state-owned general insurance companies. He is on the board of governor of a business school and National Capital Region, New Delhi. He is in honorary capacity as a financial and tax advisor of a leading Plan India not-for-profit organization which is celebrating its Century Foundation year. So I welcome Advocate C. Aseem Chawla ji here on the panel. We have with us now R.P. Garg ji. He is an ex-ITAT member. R.P. Garg ji has been as Senior Vice President of Income Tax Appellate Tribunal, specialization in taxation and corporate laws, having 50 years of experience as chartered accountant, as advocate of High Court and Supreme Court, and as ITAT member or 23 years residing and conducting second appeal arising in direct tax law and retired therein. Academically, he is a Commerce graduate, a fellow member of Institute of Chartered Accountants of India, and has a master degree in law from Delhi University, India. He is also a senior tax consultant to internationally reputed firms dealing in corporate tax and offshore transaction matters. He has been a continuous source of contributing papers in seminars and tax journals on international and Indian tax law. His recent publication in 2021 are Faceless Assessments, Appeals and Penalties, Appeals, Revision and Rectification, National Company Law Tribunal including Appellate Tribunal, covering companies at 2013, Insolvency and Bankruptcy Court 2016, LLP Act 2008, and Competition Act 2012. He has been the author of books on law and practice of tax treaties, Indian law, taxation of non-residents, international tax, law of tax treaties, practice and procedures before IPAC, capital gain transactions, student series of income tax, limitation and arbitration, and gift in tax avoidance. He has been the chairman of the Chamber of Tax Consultants Delhi chapter for consecutive 2 years, spreading knowledge in taxation stream. I welcome you, sir.
Thank you. Thank you very much.
Now I would like to call upon our session moderator, CA Sunil Garg ji, who is with us to take the introduction of the webinar and welcome our guest speakers and session.
Thank you, Geeta. And I welcome our today's session chairman, Shri R.P. Garg and our guest speaker, Shri Aseem Chawla ji, friends. Very learned speaker. And today topic, बहुत important, very important topic. And this is the only topic where the debate is not only in India, but throughout the world, the whole world is debating how to tax these digital companies. और अगर हम इसको समझें इसकी बैकग्राउंड को तो 2013 में ओईसीडी ने बैप सेक्शन प्लान में एक बैप सेक्शन प्लान बनाया बेस इरोजन एंड प्रॉफिट शिफ्टिंग और उस बैप सेक्शन प्लान की रिपोर्ट 2015 में आई एक्शन प्लान वन में तीन बातें कही थी कि आइदर यू ब्रिंग द रूल ऑफ सिग्निफिकेंट इकोनॉमिक प्रेजेंस एसईपी और यू कैन विदहोल्ड द टैक्स or a levy called equalization levy or some kind of levy, some digital tax can be levied. And in 2015, I think we brought in a significant economic presence rule, but due to the there was no rule in the tax treaties क्योंकि वहां पे परमानेंट एस्टेब्लिशमेंट था तो बहुत ज्यादा उसका इफेक्ट नहीं हुआ देन 2016 वी ब्रॉट इन इक्वलाइजेशन लेवी और सर जब हम इक्वलाइजेशन लेवी लेके आए तो बड़ा रिबेटल और जब 2020 में हमने गूगल टैक्स उसको पहले गूगल टैक्स था और जब 2020 में इक्वलाइजेशन लेवी का दायरा बढ़ाया तो विशेषकर यूएसए दे थ्रेटन्ड विद अ काउंटर टैरिफ एंड ये सब they were not happy with this equalization levy. But all of a sudden, 2020 or 2021, April 2021, now G7 has proposed the new approach of global minimum tax, and they brought in pillar one and pillar two theories. तो थ्योरी क्या है इक्वलाइजेशन लेवी का क्या इफेक्ट है and we are going to have these all these in today's webinar. In 2020, we also brought in 194O, and 194 is the tedious provision on the e-commerce. तो आपस में क्या इंटरप्ले है इनका 194 ओ का एंड इक्वलाइजेशन लेवी के साथ एक बड़ी बात है कि बिकॉज इट इज नॉट द पार्ट ऑफ द इनकम टैक्स एक्ट इट इज द फाइनेंस एक्ट 2016 तो उसका क्रेडिट ऑफ कोर्स नहीं मिलेगा टैक्स में उसके क्या इफेक्ट्स हैं और जो नया ये डेवलपमेंट हुआ है अप्रैल 2021 में और उसके बाद जुलाई 2021 में 130 कंट्रीज हैव एक्सेप्टेड दैट ग्लोबल मिनिमम टैक्स अप्रोच तो सारी दुनिया में एक बहस है इट इज बीइंग डिबेटेड नाउ हाउ टू टैकल दिस डिजिटल companies how to tax them so this is very important point this is very important debate very important topic and today we are going to be enriched by Shri Aseem Chawla ji on this topic and before that I will request Shri R.P. Garg ji to say a few words about the today topic over to Shri R.P. Garg ji.
Yes. Good afternoon to everybody.
Good afternoon.
As Mr. Sunil Garg has given the outline of the topic which Mr. Chawla will be telling us, OECD has been struggling on this taxation of e-commerce transactions or online transactions since 2013. And they could not find out any satisfactory way to tackle this problem. They have discussed 3-4 points to solve this problem or to tackle this income tax problem. But ultimately, they could not find out any solution and they left it to the government of every country to adopt either of the methods which they have discussed. Mr. Chawla perhaps will be solving that problem which OECD has been struggling for a long. India has taken some of the steps, or you may say all the steps which they have considered in piecemeal. That is, they have introduced equalization levy as against the tax, excluding it from the Income Tax Act. They are charging it on gross basis, not a part of treaty. But then how the double taxation problem will be solved, that Mr. Chawla will be addressing us. Then SEP, Significance Economic Presence concept was brought in 2018, but that also is not very successful. Then equalization levy 2 on e-commerce transactions was also introduced in 2020 with, with 2% tax on the consideration which the non-residents are receiving from the supply of the services and etc. Withholding tax was there under the treaties, but that has not been found very successful. So this is very serious position has emerged out, and the transactions are today's date. Mr. Chawla has said that it is about 1 to 1.2 million transactions per day we are having, and as this the tax problem is not able to tackle, and it is likely to be about around 200 billion dollars by 2027. And in such a situation, unless we have a safe and a viable system, this transaction tax problem will not be able to solve. And I hope Mr. Chawla will be trying, and his endeavor will be to solve all this problem, which this OECD has been struggling since 2013, and no solution is found as yet. Over to Mr. Chawla. Thank you very much.
Thank you, Garg Saab. You are a constant source of inspiration all along, especially for all your academic writing pursuits. I have done one, and I was told in good humor by a sitting honorable judge that Aseem, it's like laboring a child. And I said, well, candidly, I'm not a father, but the feeling is the same. And Garg Saab, your yeoman efforts of coming out with commentaries and professional practice books, which are such a great help. I mean, I look forward to reading, or perhaps may take this opportunity of asking if you could tell your publisher if you could send your 2021 publication, maybe an autographed copy. I will cherish that. Certainly, for the record, I must tell you that your publications of ITAT procedures is something which is my go-to guide always, and I look forward to receiving your other publications. It's such a pleasure and honor to have you, sir, here. Now, Sunilji was kind enough to lay out the outline, and he does so succinctly in all our these ongoing long journey of Webathon. Well, the wish list is too much, frankly, for the day. I don't know whether I'll be able to do justice with the global minimum tax prescription, which was a fallout or a segue to the October 29 Pillar 1, Pillar 2 uh, blueprint which the OECD had introduced. And I was fortunate enough to be in Geneva almost the same time last year when we had the UN subcommittee meeting, and we had a representative from the OECD making a presentation on Pillar 1, Pillar 2, which has led to, after the change in the administration and with the new Biden administration coming and realizing the fact that the global tax competition might result to race to the bottom. This is what the U.S. Treasury Secretary Madam Yellen Yanet has said. So I think the idea is to have that 15% floor, which Honorable Garg Saab did mention. Now, what goes into that is a fair bit of academic paper, or I mean, or an academic prescription. And why I use the term academic is not to sound belittling it for professionals, because most of us have this feel belief कि जब लेजिस्लेशन होगा तब पढ़ लेंगे यार, अभी पढ़ने की क्या जरूरत है, ये तो बार बार ऊपर नीचे उठक पुटक होती रहेगी. But then some of us are equally keen to keep pace with what all is happening and how the whole world is reacting. And India is also has affirmed its pledge amongst those 130 nations that if you decide something, we will honor that. So there are a lot of moving parts to it. अब स्टोरी क्या है, सिंपल भाषा में स्टोरी ये है कि अगर आप कंट्री ऑफ रेजिडेंस में हैं और सोर्स कंट्री से कुछ आपकी आमदन है, तो आप सोर्स कंट्री में इसलिए टैक्स नहीं होते क्योंकि आपकी एक टैक्स ट्रीटी है, और उस टैक्स ट्रीटी में आर्टिकल 5 के तहत आपका पीई नहीं है, क्योंकि ये सर्विसेज दिखाई तो नहीं दे रही. एज आई हैव रेड said in my book that with passage of time geography is becoming history. You are rendering services from one to another without the physicality of it. कोई मूवमेंट शिपमेंट नहीं है, कोई बिल ऑफ एक्सचेंज नहीं है, कोई बिल ऑफ लेडिंग नहीं है, कोई कस्टम क्लियरेंस नहीं है, कोई एजेंट नहीं है, कोई माल छुड़ा नहीं रहा, कोई यहाँ उसको बेच नहीं रहा, आपका कोई सोल सेलिंग एजेंट नहीं है, आपका कोई ठैया नहीं है. आई think the best equivalent of a permanent establishment is thaiya, as I always say. So in that sense, if you look at the Right Flores judgment of the Calcutta bench of the tribunal, which came long ago, which said that, well, you are making payments for advertisement banner to Google, Yahoos of the world, and this constitutes business income for the recipient. और गूगल याहू का परमानेंट एस्टेब्लिशमेंट उस समय या उस दौरान उस ट्रांजैक्शन पे नहीं है, तो भाई आप इसको कन्वेंशनल गिवन स्कीम ऑफ टैक्सेशन में कैसे टैक्स कर सकते हो. And then with the BEPS doctrine, Action Plan 1, Taxation of Digital Economy, 2 or 3 alternatives were propounded. One of the first alternatives was कि साहब ऐसा है फिर पी का दायरा बढ़ा देते हैं. अगर कन्वेंशनल पी में ये नहीं टैक्स होते तो हम पी का दायरा बढ़ा देते हैं. एक ये सिचुएशन है. अब पी का दायरा बढ़ाने के लिए हमने लॉ में सिग्निफिकेंट इकोनॉमिक प्रेजेंस का कॉन्सेप्ट इंट्रोड्यूस कर दिया कि सेक्शन 9 में हम सेक्शन 9 का स्कोप ही इतना बढ़ा देते हैं कि कुछ चीजें उसमें जो नहीं अभी तक फॉल इन हो रही थी वो हो जाएंगी. ठीक है, गुड आइडिया. बट देन इफ ट्रीटीज गिव यू अ बेनिफिशियल आउटकम, देन इवन इफ यू डू वट एवर यू विश टू डू अंडर द डोमेस्टिक टैक्स लॉ, अगर साफ ट्रीटी में वो बच जाता है, तो फिर डोमेस्टिक टैक्स लॉ का दरकार सिर्फ उन सिचुएशन में रह जाती है जब आप ट्रीटी क्लेम के बेनिफिट्स नहीं क्लेम कर सकते या ट्रीटी नहीं है. तो एक सिचुएशन तो ये हुई. दूसरा प्रिस्क्रिप्शन था कि साहब फिर ठीक है, अगर आप पी का दायरा भी बढ़ा सकते हो, आप एक इसको आप इक्वलाइजेशन लेवी कह सकते हैं, इक्वलाइज करने के लिए कि सोर्स कंट्री को कुछ मिले और सोर्स कंट्री का टैक्स इक्वलाइज हो जाए, तो इक्वलाइजेशन लेवी ला सकते हो. कुछ विदहोल्डिंग टैक्सेस में अमेंडमेंट कर सकते हो. पी की डेफिनेशन ही चेंज कर दो, क्योंकि आपने सिग्निफिकेंट इकोनॉमिक प्रेजेंस का कॉन्सेप्ट डोमेस्टिक टैक्स लॉ में तो ले आए, और पी अगर ट्रीटी को चेंज नहीं किया और वो अभी भी वैसे ही है, तो आप डोमेस्टिक टैक्स लॉ का दायरा बढ़ा दो, ट्रीटी वहीं की वहीं है, तो आप कहेंगे मेरे को ट्रीटी में बेनिफिट मिलता है तो मैं ट्रीटी के हिसाब से आगे चलता हूँ. तो एक एक्शन प्लान 1 बेप्स ने कहा कि साहब आप पी का डेफिनेशन बढ़ा दीजिए, कुछ नए विदहोल्डिंग टैक्सेस देख लीजिए, और अपने जो डोमेस्टिक टैक्स लॉज हैं इनडायरेक्ट टैक्सेस के, वीएटी या जीएसटी, उसमें कुछ संशोधन कर सकते हैं तो कर लीजिए. ये कुछ प्रिस्क्रिप्शन बेप्स के आए. नो रिमेंबर, बेप्स इज अ वाइट पेपर. इट इज नॉट अ सॉफ्ट लॉ और मच लेस अ लॉ इन इटसेल्फ. OECD, इकोनॉमिक फॉर कोऑपरेशन ऑफ इकोनॉमिक डेवलपमेंट, एक संस्था है जिसको यूरोप की कंट्रीज प्रिडोमिनेंटली EU की फंड करती हैं, और OECD के मेंबर्स EU और नॉन EU कंट्रीज भी हैं. इंडिया OECD का फुल मेंबर नहीं है, हम सिर्फ ऑब्जर्वर की कैटेगरी में जाते हैं. और भला हो G20 और ग्लोबल फाइनेंशियल क्राइसिस का कि G20 डेवलपिंग नेशंस को एक स्थान मिला उस टेबल पे आने का जो एक G7 ग्रुप ऑफ नेशंस का प्रेरोगेटिव था। मैं अपनी इस भूमिका को ज्यादा लंबा स्ट्रेच नहीं करता और सीधा सब्जेक्ट पे आता हूँ, बट सब्जेक्ट को समझने और अप्रिशिएट करने के लिए ये मुख्य तौर पे बातें जरूर ध्यान में रखनी है। जो हमारे फंडामेंटल्स हैं कि एक स्टेट ऑफ सोर्स है जहाँ से इनकम की उत्पत्ति होती है, फ्रॉम वेयर द इनकम ओरिजिन्स, which is the source state, which is from where the fountain emerges. Then there is a state of residence in which the payee who is entitled to that income is a resident of for tax purposes. And now there is a new state actor. इस पुरानी कन्वेंशनल स्टोरी में एक तीसरा एक्टर आया, वो है कंट्री ऑफ मार्केट। तो कंट्री ऑफ सोर्स, कंट्री ऑफ रेजिडेंस और कंट्री ऑफ मार्केट। तो मार्केट जुरिस्डिक्शन मतलब जिस वजह से आपका सामान बिक रहा है या जहां पर एक बहुत स्ट्रांग मार्केट है, वो उस मार्केट को भी दरकार है कि भाई मुझे भी कुछ मिलना चाहिए। अब व्हाट्सएप को आप ले लीजिए एज अ प्लेटफॉर्म। WhatsApp has maximum subscribers, I am told, in India, and WhatsApp may have source of income from many countries, let's say as part of the Facebook uh, group, so to speak. And if Facebook is earning income from many countries, then because of the fact that it has a strong subscriber base in India, there are many companies in many parts of the world who are willing to do their advertisement and make the WhatsApp as a platform which has a great market or a value. अब अगर इतनी स्ट्रांग मार्केट नहीं होती तो फेसबुक का इतना, सॉरी, फेसबुक कंबाइंड व्हाट्सएप कुछ भी प्लेटफॉर्म ले लीजिए, उसकी इतनी वैल्यू ना होती। तो सोर्स कंट्री से कमाया हुआ कंट्री ऑफ रेजिडेंस में उस एंटिटी को उसका हक है, बट मार्केट जुरिस्डिक्शन कहते हैं कि साहब आप कमा तो रहे हो, बट ये मून शाइनिंग हमारी वजह से हो रही है, तो हमें इसका हिस्सा दीजिए। टू पुट इट इन वन लाइन, now conventional rules of taxation have never envisioned this. Conventional rules of taxation have said that income has to be allocated between source state and state of resident, और tax treaty का मुख्य function है allocation of taxing rights. It does not restrict taxing right, it only allocates it. अब ये तीसरा state actor आ गया, तो भैया अब क्या करें? What should we be doing? So as BEPS has mutated, and I know mutated is not a very happy word in the corona times, BEPS has mutated, and the last action plan of multilateral instruments has resulted in an MLI sort of a situation, which is a one common template like a stencil, जिसके उसको अब आप टैक्स ट्रीटीज के साथ पढ़ेंगे। अब MLI ने अपना प्रिस्क्रिप्शन दे दिया, कंट्रीज ने उसको बाइन दे दिया, इंडिया ने भी बाइन दे दिया, बट उससे भी ये प्रॉब्लम सॉल्व नहीं होती। उससे कुछ टैक्स इवेजन, टैक्स अवॉइडेंस की प्रॉब्लम, एंटी फ्रैगमेंटेशन की प्रॉब्लम सॉल्व होती है। मैं इसको बड़ा ओवर सिंप्लीफाई करके बता रहा हूँ, ये इतना आसान बिल्कुल भी नहीं है इफ यू गो इनटू द डिटेल्स, बिकॉज दिस प्रिस्क्रिप्शंस आर दे रन इनटू मिल्स ऑफ पेजेस। अपने आप में ये इतना जबरदस्त और इंटरेस्टिंग लिटरेचर है जिसको समझने के लिए बहुत पेशेंस और you need undivided attention as much as senior Garg Sahab would do while writing his books.
That is where your acumen is required.
Right. Now, अब MLI भी हो गया, बट वो कंट्री ऑफ मार्केट और कंट्री ऑफ रेजिडेंस और कंट्री ऑफ सोर्स का जो ये डिस्ट्रीब्यूशन ऑफ टैक्सेस है, जिसको सुनील भाई ने भी समझाया कि भाई ये 130 कंट्रीज ने अब कहा है कि ठीक है भाई मिलके ये भी डिसाइड कर लेते हैं। अब इसके लिए क्या एक और MLI आएगा या सारी की सारी ट्रीटीज अमेंड होंगी? इंडिया की लगभग 100 से कम ट्रीटीज हैं, उनमें संशोधन होगा या कोई एक कॉमन फिर एक टेम्पलेट आएगा, उस हिसाब से ट्रीटीज अमेंड होगी, या एक कोई और टेम्पलेट आएगा? तो एक टैक्स ट्रीटी हो गई, एक MLI का टेम्पलेट, एक नया टेम्पलेट आएगा। इन तीनों टेम्पलेट को पढ़ के आप डिसाइड करोगे कि भाई अब करना क्या है इन सो फार एज those situations where an entity has to distribute its revenues with its country of residence, with the country of market and with the country of source. ऐसी entities जिनका 750 बिलियन यूरो से ज्यादा टर्नओवर है, वैसी कुछ एंटिटीज अभी भी इस I mean, they are present in this world. I mean, the big ones, the FANGs, the Facebook, Amazon, Netflix, Googles of the world, and couple of others to whom this third template will be applicable. So, with this little background, if one has to move forward, that BEPS action plan one had recommended something known as equalization levy. अब ये equalization levy का स्वरूप क्या है? क्या ये डायरेक्ट टैक्स है? क्या ये कॉर्पोरेट टैक्स है? क्या ये इनकम टैक्स एक्ट के अंदर आता है? अगर आप इक्वलाइजेशन लेवी के प्रोविजंस को इनकम टैक्स एक्ट में ढूंढेंगे तो बिल्कुल प्लीज गलती मत कीजिए, क्योंकि इनकम टैक्स एक्ट में इक्वलाइजेशन लेवी की कोई झलक सिर्फ उतनी ही मिलेगी जहां पर इनकम टैक्स एक्ट उसको इतना रिकॉग्नाइज करता है कि जहां इक्वलाइजेशन लेवी साहब पे हो गया तो वो सेक्शन 10 में इनकम एग्जेम्प्ट है। बट उसके अलावा इक्वलाइजेशन लेवी के क्या प्रोविजंस हैं, क्या प्रावधान हैं, क्या सेक्शंस एंड सब सेक्शंस हैं, यू हैव टू गो टू फाइनेंस एक्ट 2016. It is akin in terms of its legislative form, like Finance Act 1994 gave the Service Tax Act, which we all were underestimating the power of service tax in 1994 कि साहब ये कुछ services पे आया है. Little we knew that service tax will take the center stage of indirect taxes, and so much so that will result in the great big bang of GST. Remember, Service Tax Act was never codified anything apart from Finance Act 1994. It never became Service Tax Act. Its genesis was always the Finance Act 1994, and the amendments kept on happening. We never had something known as Service Tax Act. Similarly, we do not have a Equalization Levy Act. We have, by virtue of Finance Act 2016, a levy which is a tax. Now you can argue whether it is an indirect tax or a direct tax, whether the state has the legislative competence in terms of the Constitution of India to levy such a tax. Right? You can continue to debate and argue about it, whether such a tax could have been levied. क्लियरली इफ इट इज नॉट एन इनकम टैक्स एक्ट तो साहब मुझे वो टैक्स देने के बाद उसका कोई क्रेडिट ही नहीं मिलेगा, बिल्कुल नहीं मिलेगा. अगर उस टैक्स का क्रेडिट आपको मिल जाएगा तो सारा पर्पस ही डिफीट हो जाएगा. पर्पस क्या था कि आप कंट्री ऑफ रेजिडेंस में एक फेसबुक है या एक गूगल है या एक कंपनी है जिसकी एक वर्चुअल प्रेजेंस है और उसको एक इनकम मिलती है और उस इनकम का जरिया भी एक वर्चुअल जरिया है. तो अगर आपने उसको टैक्स क्रेडिट दे दिया तो अल्टीमेटली तो फिर कंट्री ऑफ सोर्स या कंट्री ऑफ मार्केट को कुछ मिला ही नहीं. सो देयरफॉर प्रोवाइडिंग अ टैक्स क्रेडिट टू सच अ सिचुएशन.
टैक्स क्रेडिट तो वो कंट्री ऑफ रेजिडेंस जो लेवी करती है उसका मिलता है ना.
एग्री, बट क्वेश्चन, हाँ बिल्कुल ठीक बात कर साहब. क्वेश्चन ये था कि भाई ईएल का टैक्स क्रेडिट नहीं मिलता. ईएल का टैक्स क्रेडिट अगर मिल गया तो वो जो पर्पस ईएल लाने का था वही डिफीट हो जाएगा. भाई ईएल का पर्पस क्या था कि आप कुछ सोर्स कंट्री में टैक्स दें, राइट. इसीलिए उसको ट्रीटी के माध्यम से नहीं लाया गया, क्योंकि मैं अगर ट्रीटी के माध्यम से वो आता और यहाँ पर कन्वेंशनल आर्टिकल 5 का पी नहीं होता तो या तो वो डिफीट हो जाता पर्पस, या वो अगर टैक्स लगता तो उसको आर्टिकल 22-23 में क्रेडिट मिल जाता. तो फिर राइट.
So credit was given only when the source this residence country also taxes that income.
Yeah, but then that credit will not be a credit under the treaty.
Under their individual acts, like that equalization levy.
बिल्कुल, क्योंकि ये फाइनेंस एक्ट 2016 से आया. नाउ entry 82 of union list, in my view, very broadly speaking, I'm not a constitutional lawyer expert, but I love reading constitution because वही उत्पत्ति वहीं से हुई है, वही गंगोत्री है, वही ग्रंथ नॉर्म है, you know. So all the laws will find their genesis in the constitution. Now entry 82 of union list does suggest the fact that there is a legislative competence to levy such a kind of prescription. उसको अगर आप थ्रेड हेयर स्प्लिटिंग कर भी लेंगे कि ये डायरेक्ट है या इनडायरेक्ट है, अगर स्टेट की लेजिस्लेटिव कॉम्पिटेंस है उसको लेवी करने की, तो उस fine hair splitting में what utility will be served? I mean, I would need to know from a professional practice point of view.
But this
Now,
FTS and royalty are also taxed on gross basis, na?
but agreed. FTS
Uh,
and royalties
That is
are
under
taxed
Income Tax
on
Act.
gross basis, but then they are subject. They are under the Scheme of Income Tax Act. RP Garg Sahab, unlike other treaties, it's not a final discharge.
Yeah, yeah,
As
yeah.
you are very well aware, in European countries एक बार withholding tax दे दिया जान छूट गई. अभी हमारे यहाँ तो है कि भाई withholding tax तो is the beginning of the great saga,
Yes, yes, yes.
and it may not result in a final discharge, and that's how
Yes,
Section 195 is worded.
that is only advance.
Yeah, that's only a preponement of collection of taxes and an advance collection of tax.
Correct.
Now, now one will argue the fact that okay, Article 246 capital A of the Constitution, and if you are dealing with a situation of taxation with relative, which is relatable to consideration of supply of goods vis-a-vis entry 97 of Union List, और अगर इसका स्वरूप इनडायरेक्ट टैक्स का है, मैं कॉन्स्टिट्यूशन के कुछ प्रोविजंस को पहले डील कर लेता हूं, and then we will come to the presentation, and hopefully this very good hard work done by the team, Pulkit, Sonia, Ashish and Shikha, and predominantly the heavy lifting done by Pulkit on 60 odd slides is a good material. But today's endeavor is that if we can understand the concept, and this material, I'm sure good officers of Raji and with the help of Sunil Bhai will be made available to you, and you can keep this as a good reference material. But remember, it's not a substitute of reading Finance Act 2016, जहाँ से EL की उत्पत्ति हुई,
Correct.
and the iterations which we saw in the subsequent Finance Act 2020 and 2021 will come to the slides a little later. Now, coming and running the full circle on the constitutional aspect of it, there are only two more points I have to say. कि अगर इसका स्वरूप indirect tax वाला है, then EL is not based on the recommendation of the GST Council, and therefore it violates Article 269 capital A of the Constitution, assuming it has the caricature look and feel of an indirect tax. Coming to the aspect of the last remaining aspect, and maybe मैं सीनियर गर्ग साहब से भी उसमें रिक्वेस्ट करूंगा on the aspect of extraterritoriality of the equalization levy provision. Although the sort of the contention of extraterritorial levy of taxing statute is not buried in a very satisfactory manner, and the issue is still wide open. Even in the cases of GVK Industries, which followed the decision of Electronic Corporation, the Supreme Court could describe the situation to describe it, but it has not been properly or final, as they say, it has not been very properly nailed it down. कि क्या स्थिति है, वो क्या प्रिस्क्रिप्शन है एक्स्ट्रा टेरिटोरियलिटी का.
No, some connection is established, then it doesn't become extraterritorial.
Agreed.
And the connection is that sale market is in India. So therefore, it may not be, according to me, it may not be extraterritorial
Right.
legislation.
Now, अब
But
गर्ग
still,
साहब ने
the
बड़ी
question is to be debated.
right. गर्ग साहब ने बड़ी अच्छी बात कही कि if the connection, if the nexus is established, then it does not fall foul of Article 245 of the Constitution. Now the question is, what are the situations, or what are the parameters, or what is that mantra, or what are those guiding principles of qualifying or constituting a nexus?
Yeah.
वो गाइडिंग प्रिंसिपल्स जब तक नेल डाउन नहीं होंगे, with some guidance coming from the Supreme Court, and maybe sooner or later these matters will reach the Supreme Court. I hope they reach sooner than later, but till such time वो स्थिति बनी रहेगी. Now, with this, I think we should move a little more on this, and Shruti, may I request you to just flip the slides, please? Yeah. So, as I said, with the little background which we've done, we'll look at the India's digital taxation pursuit. The most important piece of material in terms of persuasive reading is the equalization levy proposal, which was recommended by the Committee on Taxation of E-commerce. It's a 100-page plus document, but to me it is worth reading, and it really gives you a sense as to how and why this Finance Act 2016 did legislate it. So anybody who's trying to interpret the provisions of Finance Act 2016 will not be able to do justice if he or she doesn't read the report of the Committee of Taxation of E-commerce. So this is a little bit background on e-commerce. I don't have to tell you. I mean, I think e-commerce post-COVID and otherwise also is pretty much now a talking point in every manner in our Indian society. So
But
imagine that
report
there are
report also doesn't give any solution. It just poses the
हाँ
question
हाँ वो
and
रिपोर्ट
goes
उसी तरह है जिस तरह वो डेयर ऐसे जीवी के इंडस्ट्रीज का फैसला है सुप्रीम कोर्ट का कि
correct,
नेक्सस
correct,
होगा तो टेरिटोरियल है अब नेक्सस क्या है ये नहीं पता.
correct, correct.
Now, you will be surprised that there are about 1.2 million transactions per day in e-commerce retailing only. 10 से 12 लाख transactions रोज सिर्फ रिटेल साइट पे ई-कॉमर्स पे भारतवर्ष में होती हैं. So
That
this
is
is
that
the
is the number of transactions, not the in rupees or dollar.
no, just the number of transactions.
Number of.
और वो भी सिर्फ रिटेल में. ई
Yeah.
कॉमर्स का तो बहुत बड़ा दायरा है, बी टू बी भी हो सकता है. अगर आप सिर्फ बी टू सी की बात करें गर्ग साहब तो सिर्फ 10 से 12 लाख ट्रांजैक्शन पर डे होती हैं. ये
Correct.
एक एस्टिमेट है. सो आप इमेजिन करिए कि इनकम टैक्स डिपार्टमेंट के पास क्या बढ़िया ये एक एडिशनल सोर्स ऑफ रेवेन्यू है. और वो एडिशनल
Source of revenue. Correct.
भाई सीधी सी बात है, 2016-17 में इक्वलाइजेशन लेवी से मात्र कलेक्शन हुई 200 करोड़. और 2021 के जो मेरे पास जो एस्टिमेट्स और जो फिगर्स हैं जुलाई तक के, द इक्वलाइजेशन लेवी मॉप अप वाज 2000 करोड़. सो फ्रॉम 200 करोड़ इन 5 years we have jumped to 2000 crores, 10 times. So see the magnitude of the amount of collection which is happening in equalization levy only, and the comparison of 2021, which is 2000 crores, is very startling with the immediately preceding year 1920, where the collection was only 1000 crores. So in 1 year it has doubled.
The
And in
400
5
crore,
years,
if we take 2% as the base, then 400
हाँ,
crore will be the collection.
या कलेक्शन और 16-17 से कंपेयर करो तो ये 10 गुना बढ़ गया. तो ये भी स्टॉक मार्केट की तरह दौड़ता जा रहा है. सो दिस इज अ सिचुएशन. अभी तो इसमें जो 6% का पूरा इम्पैक्ट है जो अमेंडमेंट हुआ एक्ट में, जिसको अभी हम डिस्कस करेंगे, वो भी ठीक से नहीं आया. क्योंकि ये उसको अगर आप ठीक से ऐड करेंगे तो आपकी बात ठीक है. Maybe when we discuss this, maybe sometimes next year, you may find this figure getting nudged up by more than CAGR growth also.
Yes.
Right? Now the question is, जो सुनील भाई का प्रोपोजिशन था कि साहब जब ये ग्लोबल मिनिमम टैक्स और ये डिवीजन और ये बंदरबाट एग्री हो जाएगा तो क्या होगा. अगर ये ग्लोबल मिनिमम टैक्स 22-23 की जो टाइमलाइन है वो एग्री हो जाएगा तो हमारे को ईएल हटाना पड़ेगा.
No, naturally.
तो फिर एज अ मार्केट जुरिस्डिक्शन और एज अ सोर्स कंट्री विच आई एम श्योर इज वेरी वेरी लाइव विद नॉर्थ ब्लॉक, they would have done their number crunching that we will not be worse off than what the collections would be at next year, or rather will be gaining something. Otherwise, why will you accept the global minimum tax?
Then
Today
market country will be not able to collect it, na?
हाँ, अब मार्केट कंट्री उस फॉर्मूले के हिसाब से कितना कलेक्ट कर पाएगी, सोर्स कंट्री कितना कलेक्ट कर पाएगी।
हाँ, वो तो सोर्स की बेस पे डिपेंड
हाँ,
करता है।
अब क्या वो कलेक्शन हमारी 2-2.5 हजार करोड़ से ज्यादा होगी, ये देखने वाली बात है।
हाँ, वो तो अनलेस द ट्रीटी इज एक्सप्लेन्ड प्रॉपरली इट कांट बी।
Right. So what happened? So let's move forward. Next slide, please. So this is the little background. I think we've spoken about it. We could move forward. This is taken care of. Next slide. Yes. तो पिलर 1 बेप्स एक्शन प्लान ने कहा कि भाई ये चीजें हम कुछ कर सकते हैं, ये कुछ रिकमेंडेशंस है हमारी। ओईसीडी ने कहा कि आप देख लीजिए आपको क्या ठीक लगता है। तो इंडिया इजराइल ने कहा चलो हम सिग्निफिकेंट इकोनॉमिक प्रेजेंस को लेजिस्लेट कर लेते हैं। सऊदी अरेबिया ने कहा हम वर्चुअल पीई को कर लेते हैं।
इंडिया हैज
सम
अडॉप्टेड
कंट्री,
ऑल।
यस, सर्विस,
They have adopted all.
हाँ, they have all adopted. This is anecdotal. This is all
Correct, correct.
anecdotal. हंगरी ने एडवर्टाइजमेंट पे एक टैक्स लगा दिया, इंडिया ने इक्वलाइजेशन लेवी लगा दिया, यूके ने लगा दिया, फिर एंटी अवॉइडेंस प्रोविजन के लिए यूएस ने बीट लगा दिया, जो हमारा गार का एक कजन वर्जन है। बेस इरोजन एंड एंटी अवॉइडेंस को यूएस में बीट बोला जाता है। ठीक है, यूके और ऑस्ट्रेलिया ने डाइवर्टेड प्रॉफिट टैक्स लगा दिया। सो ये करके कुछ कंट्रीज ने फटाफट लेजिस्लेट करना शुरू किया और इंडिया वाज नंबर 1 इन टर्म्स ऑफ लेविंग डिजिटल सर्विसेज टैक्स, डीएसटी बोले, गूगल टैक्स बोले, इक्वलाइजेशन लेवी बोले, इसके ये डिफरेंट नॉमेनक्लेचर्स हैं। लेट्स मूव फॉरवर्ड।
How they have distinguished equalization levy and this e-commerce levy?
जो
There
194
2% and there they are charging 6%.
वो
Both are
आते हैं।
services.
हाँ ठीक है, वो फाइनेंस एक्ट में जो डेफिनेशंस चेंज की गई ना गर्ग साहब,
हाँ,
उसमें दिया गया, वो आगे वाली स्लाइड्स में कवर करता हूँ।
अच्छा अच्छा अच्छा।
ठीक है, ओके, लेट्स मूव फॉरवर्ड।
हम्म।
So, just to help in understanding what were the key milestones, report आया e-commerce कमेटी का 2016 में। As I said, this report is worth reading. Please read this report. At least gives you some preface, may not give you all the answers, but it will help you in identifying the issue and help you in developing some thought process. रिपोर्ट के आने के बाद जो पहली फर्स्ट अवेलेबल अपॉर्चुनिटी थी बजट की, उसमें हमने इसको लेजिस्लेट कर दिया। फिर इनडायरेक्ट टैक्स में हमने ओआईडीआर रिजीम ले आए, जिसको ऑनलाइन इंफॉर्मेशन डेटाबेस एक्सेस एंड रिट्रीवल स्कीम लाते हैं। फिर एसीपी का कॉन्सेप्ट हम 2018 में लाए। 2020 में जो हमने फाइनेंस एक्ट 2016 में इक्वलाइजेशन लेवी इंट्रोड्यूस किया था, उसको हमने स्कोप इनलार्ज किया, वही गर्ग साहब का प्रश्न था। Then 194O was introduced with regard to TDS on e-commerce participants. ACP की डेफिनेशन हमने अमेंड करी और 2A और 3A के साथ एक एक्सप्लेनेशन आया, इंसर्शन ऑफ एक्सप्लेनेशन 3A। और 2021 में कुछ क्लैरिफिकेशंस और मॉडिफिकेशन आई, जो इक्वलाइजेशन लेवी का स्कोप हमने 2020 में इनलार्ज किया। रिमेंबर 2020 स्कोप इनलार्ज हैपेंड विदाउट एनी सिग्निफिकेंट डिबेट as such. And 2021, we also know that the amendments, if my memory serves me right, were the amendments not originally there in the finance bill, they came later. And therefore, there is not much of public participation or debate with around at least the amendments which were made in 2021 and 2020, broadly speaking. Let's move forward. Now, this also we've very nicely discussed, so I think we can give this slide also a pass. राइट फ्लोरिस्ट का केस के मैंने बारे में आपसे डिस्कस किया। सिमिलरली याहू का केस था मुंबई ट्राइब्यूनल का, उसमें एडवर्टाइजमेंट जो डिपार्टमेंट ऑफ टूरिज्म के वेबसाइट के पोर्टल से रिलेटेड थी, इनकम वाज नॉट रिगार्डेड एज एन इनकम अंडर द डेफिनेशन ऑफ रॉयल्टी बट वाज बिजनेस प्रॉफिट, एंड बिकॉज याहू डिड नॉट हैव अ पीई, it was not regarded as chargeable to tax in India, right? Similarly, you have the decision of Pubomatic which followed the Yahoo decision, and therefore the need was felt that under the scheme of the present act read with treaties, we cannot tax such things. So how do we tax it? Either amend the treaty, amend the act, or bring something. So they brought this equalization levy because एक्ट को भी अमेंड कर देते और ट्रीटी नहीं अमेंड करते तो पर्पस नहीं सर्व होने वाला था, राइट? क्योंकि वो ट्रीटी से फिर निकल जाता. So now let's move forward to this Genesis, which got invented or legislated in 2016. So it introduced 6% only on online advertisement and provision of advertising space and resulted and similar services. Only on these categories, no other category. And it was enacted by virtue of a separate chapter, Chapter 8 in Finance Act 2016. And similarly, or consequently, or as a corollary, Section 10, subsection 50 was amended that income tax exemption will be provided on which EL is charged. Now you can say by virtue of this corresponding exemption, this is also income tax. But that's not the case in its purest sense. 1050 यही कहता है कि जिस इनकम पे EL टैक्स हो गया है उस पे हम इनकम टैक्स नहीं लगाएंगे. So there will not be any double taxation, but it is not a case of double income taxation. And similarly 40AIB जो provisions हैं which are punitive provision with regard to add back of incomes on which tax ought to be withheld or deducted, and if you don't do that and you add it back in the in computing your assessable income, more particularly chapter dealing with PGBP, उसमें एक अमेंडमेंट होगी कि अगर EL का डिडक्शन नहीं हुआ तो हम उसको वही ट्रीटमेंट देंगे जो TDS के नॉन डिडक्शन पे होता है. In other words, if a income was subject matter of EL and EL has not happened, we will add back that expense, corresponding expense, in the books of the payer.
But that has to be allowed as a deduction, income expenditure, like sales tax.
Yes, but
And
वो बात ठीक है.
only prohibition to allow is the income tax or wealth tax or surtax. If it is not that, equalization levy has to be treated as a other tax, and
Right.
that has to be allowed as a deduction.
Yeah, but where they varied it and brought a fine distinction was to bring it at the same level as if you bring other elements of income under 40AI or 40AIA.
Correct.
Right. Then Finance Act 2020 broadened the scope. No, go back to the slide. Where they expanded the scope, and from those 3 or 4 category of service which were identified in Finance Act 2016, by Finance Act 2020 with effect from 1st April 2020, they amended the scope and ambit of equalization levy, and in a sense equalization levy on e-commerce, now that era got assured. और इसकी एक रेलेवेंट नोटिफिकेशन टीपीएल की 27th में 2016 के, for those of you who are interested, the notification number has been helpfully provided. Let's move forward.
So e-commerce is also excluded from income.
अगर उस पे ईएल लग गया तो हाँ, तो वो 1050 में आ जाएगा. Right? Now go. No. You jumping to it. Can you go back? Slide 10, please. Yeah, this is the notification. Now let's come to slide 11. So the committee of e-commerce, which was constituted by CBDT, at that point in time recommended that you impose 6%. But remember in 2016 when EL was imposed on specified service, it was 2%. But the recommendation did suggest 6%. Those recommendations in one way or the other were found favor when the scope of EL was enhanced in 2020 and EL was introduced on e-commerce related transaction. Now what happens in 2020, that EL will be charged at the rate of 6% of the amount for any specified service or services receivable by a person being a non-resident. Remember, it deals with non-resident, from a person resident in India or a non-resident having a permanent establishment in India. Two things must be satisfied.
Suppose they are
For
receiving
six,
from non-resident who is not having permanent establishment, then it will not be levied.
yes, मास्टर कार्ड में यही तो इशू आया जब मैटर अभी हाई कोर्ट में सब जुडिस था कि साहब आप बताइए आप क्या करेंगे हमारे साथ।
Yeah.
अगर आप एलिज कर रहे हैं मास्टर कार्ड में कि हमारा यहाँ पीई है
Hmm.
तो आप क्लैरिफाई कर दीजिए। सो कोर्ट, दिल्ली हाई कोर्ट हैज गिवन अ हेल्पफुल इंटरलोकेटरी ऑर्डर ऑन दैट काउंट कि हमने एलिज किया है पीई है
Hmm.
तो फिर मेरे को ईएल नहीं देना पड़ेगा क्योंकि मैं I am challenging the AR order. So High Court has said till the disposal of the appeal, you will not have to pay EL because the government is revenue is saying that you have a P. I am not saying I don't have a P. So to that extent, they have given that interlocutory order ताकि वो दोनों तरफ से ना पड़ जाए situation.
Then the market concept is diluted then. Huh?
Yeah.
Ah.
So coming to the second column of the slide, the first column deals with the eligible service provider in simple sense. The second column of the slide is what is that the scope of it is. If the service provider, the non-resident, is providing specified service in a situation where it has a permanent establishment and the specified service is effectively connected with the permanent establishment, which is a settled principle of international taxation. The aggregate amount of consideration for specified service received or receivable by a person by the non-resident from a person resident in India, threshold is 1 lakh of rupees, or where the payment is made by the person resident in India or the permanent establishment in India is not for the purpose of carrying out income chargeable to tax in India, which is a source rule exclusion. 1 लाख रुपए की थ्रेशोल्ड है इस पे, और अगर if these services are relatable for not carrying business in India, then the whole nexus in a way fails. And similar provisions are there in section 9 in case of royalty and fee for technical services also. You have the exclusion rules with regard to with regard to such situations. Next slide, please. Now, this particular graphic sort of explains everything in a very succinct manner. That the section 164 and 65, not of Income Tax Act, but of Finance Act 2016. Again, I am repeating. Please don't look at 164 of Income Tax Act and say ये तो EL के बारे में कुछ बोलता ही नहीं है, बोलेगा भी नहीं, right? Equalization levy means tax levied on consideration received or receivable for any specified person service under the provisions of the chapter, and specified service are those services which are identified. The word online has been defined. Online means a facility or service or right or benefit or access that is obtained through the internet or any other form of telecommunication network.
This aggregate amount is vis-a-vis the person or vis-a-vis India?
No, person.
Person.
Suppose from person क्वे इंडिया, नो हम तो यही देखेंगे हमारे यहाँ से कितना कमा रहे हो आप.
No, suppose two persons are doing, but they are 90-90. Instead of 1 lakh, they are 90-90. So then it will not be levied.
Yeah, then it will not be levied. Because it says unless the aggregate amount for specified service exceeds 1 lakh of rupees in any previous year.
That's what I am asking. Aggregate amount vis-a-vis India or vis-a-vis a person?
Vis-a-vis person. From consideration
from India,
from India.
That of course is there.
कोई person, कोई a non-resident. Right. Next slide, please. So this is what we have done. We've looked at why this EL is so important, because this is the Facebook's top line from India. Facebook earns about 120 odd crores. Google earned about 4,000 crores in 2014-15. So you can imagine how much they would be earning now. That is why there is a 100% increase in the collection of EL, right? Then there are some consequences which are similar to consequences under the normal scheme of the act with regard to interest and penalty, which are helpfully described in this table. Now let's move forward. Next slide, please. So, is it a unilateral levy contrary to good faith principle? Treaties were signed in good faith, principle of fairness, and a few articles of the Vienna Law of Convention. You can agree and continue to debate, but the position is India has exercised its legislative competence franchise. Now you can say that we have disregarded tax treaties, and tax treaties have to be interpreted in good faith, and directive principles under the constitution says that treaties are superior law. So be it. We have done that. So let's move forward. Now 2% situation is very easily described here, which is the left side of the left column. The right column deals with e-commerce supply of service, which is the enhanced scope of equalization levy as legislated White Finance Act 2020, which says online sale of goods or online provision of services or online sale of goods or provision of services if both are facilitated by e-commerce operator or any combination of the above, right? इसमें शुरू के अगर आप एक जो शुरू का अगर आप ग्राफिक देखते हैं, उसमें थर्ड जो बकेट है वो बहुत इंपॉर्टेंट है, जो ऊपर में मैट्रिक्स दिया हुआ है. इट सेज a person who buys such goods and service using an IP address in India. तो अगर आपने इंडियन आईपी एड्रेस से खरीद लिया तो भी लगेगा, चाहे आप लंदन में बैठे हो. तो इंटरनेट प्रोटोकॉल एड्रेस अगर इंडियन है तो ईएल देना पड़ेगा, भला कि बनिस्बत ही कि आपने ये परचेज आउटसाइड इंडिया की हो. बट अगर आईपी एड्रेस इंडिया का है तो ईएल लगेगा, regardless of the fact that I am outside India and the supplier is also outside India and I have effected that transaction sitting outside India and I have received those goods or services again outside India. Unless and until I say that I have utilized for carrying on business outside India, वो हमने शुरू में देखा. बट आप ये नहीं कह सकते कि मैं इंडिया से बाहर ट्रांजैक्शन करूं तो मुझे ईएल नहीं लगेगा. That's not an absolute correct statement. If I use the Indian internet protocol, then there is an exposure of levy of equalization levy. Okay, next
What
slide.
is this sale of advertisement?
जो आप ये एड बैनर वगैरह जो हम देखते हैं, जब आप YouTube वगैरह देखते हैं तो उसमें कुछ बैनर्स आ जाते हैं, कुछ एड्स आ जाती हैं, फिर आप उसको स्किप एड का बटन दबाते हैं.
That doesn't come in service.
No, that comes in advertisement. Of course, now the definition is enhanced. आप वो skip ad का आप जब बटन दबाते हैं, somebody is paying to the platform, let's say YouTube, कि साहब आप ये ad मेरी चलाइए, और फिर वो artificial intelligence से वो ad उन्हीं को दिखाता है जिनका वो they are able to mine the fact that whether RP Gargsa will be interested in the ad of a homeopathy medicine or a yoga class.
No. Advertisement here, they are charged at 2%.
हाँ जी.
And advertisement at the equalization levy, they are charged at 6%. How do you
No,
distinguish
2%. 6% is for these services. For e-commerce supply or service, and e-commerce supply of service is different from the advertisement thing.
equalization levy is on advertisement, ना?
No, गर्ग साहब, शुरू एडवर्टीजमेंट से हुआ 2016 में, और 2020 में अब 6% इस पे आ गया. इस पे भी आ गया.
अच्छा.
Right? So e-commerce supply or service are the following categories of e-commerce supply of service, which you find in the explanation column. Online sale of goods, online provision of service, online goods and provision, uska combination, sale of advertisement which targets an Indian customer, sale of data collected from Indian resident from person who uses IP address located in India, right? Section 164 CB. Next slide, please. Now, who is a service recipient? That also is defined. 2% under 165A, which are the categories of income which are exempt, which are categories of activities which are exempt, which are there. Exemption for income tax is in 1015. Let's move forward. What were the amendments made by budget to 2021, which of course is now legislated, now it is part of Finance Act 2021. जो हेल्पफुल अमेंडमेंट थी वो ये थी कि प्रोवाइजो इंसर्ट हुआ कि जहां पर कंसिडरेशन फॉर स्पेसिफाइड सर्विस थी वो नहीं इंक्लूड होंगी जो टैक्सेबल है रॉयल्टी या एफटीएस में, ताकि डबल टैक्सेशन ना हो जाए। एक डाउट ये था कि अगर रॉयल्टी और एफटीएस का ट्रांजैक्शन ऐसा है जो स्पेसिफाइड सर्विस में आता है तो क्या दोनों लगेंगे?
या खाली 2% लगेगा।
हाँ, कि वो
बेनिफिशियल।
हाँ, राइट। Then there was another explanation which was inserted that online sale of goods or online provision shall include one or more of following activities. Now one and more of following activities है, ये नहीं कहता all of following activities. So offer for sale, acceptance of purchase order or payment of consideration, supply of goods partly or wholly. मैंने इंटरनेट पे जूता देखा, शोरूम गया,
कॉन्ट्रैक्ट एक्ट वाले आ गए सारे सेल्स।
हाँ, सारी चीजें तो कॉम्बिनेशन भी हो गया इसमें, राइट। शोरूम पे मैं जूता देखने गया, आया, मैंने ट्रांजैक्ट कर लिया ऑनलाइन प्लेटफॉर्म से, या ऑनलाइन मैं फिजिकली खरीद के आया बट ऑर्डर मैंने प्लेस कर दिया ऑनलाइन प्लेटफॉर्म पे, डिलीवरी लेने में खुद चला गया, या ऑनलाइन मैंने कंसिडरेशन पे कर दी और फिजिकली सप्लाई हो गई, तो सब चीजें उन्होंने कवर कर दी टू कवर
कंसिडरेशन कवर्स एवरीथिंग ना। देन व्हाई दे हैव सेपरेटली सेड एक्सेप्टेंस ऑफ और प्लेस एंड एटसेट्रा।
वो उसका कारण ये है कि आप ये आर्ग्यू कर सकते हो कि साहब मैं तो गया था स्टोर पे खरीदने, तो ये तो ऑनलाइन ट्रांजैक्शन ही नहीं है।
अच्छा,
मैं और घर के फैमिली मेंबर्स गए, हमने एक गैस चिमनी खरीदनी थी, हम फिजिकली हार्डवेयर गोदरेज का दुकान पे गए, लेट्स
और
से
पेमेंट कहीं बाहर से कर दिया तो मुश्किल हो जाती है।
हाँ,
करेक्ट।
तो वो सब कॉम्बिनेशन कवर कर लिया। ऑफ कोर्स वी आर टॉकिंग ओवर नॉन रेजिडेंट सिचुएशन। व्हेन आई यूज द वर्ड गोदरेज, आई एम सेइंग लेट्स से गोदरेज हैज सम, let's say I'm talking about Godrej UK, so to speak, or XYZ UK. Then clause B was inserted in section 165 capital A3, which says that consideration for sale of goods irrespective whether e-commerce owns the goods, excluding however consideration for sale of goods which are owned by Indian resident or P if such sale is effectively connected with the P. एक क्वेश्चन ये था कि साहब मैं प्लेटफॉर्म हूं, मैं अमेजॉन हूं, मैं सब कुछ तो ओन नहीं करता, तो क्या वो उस सिचुएशन में क्या इक्वलाइजेशन लेवी लगेगा? तो
एसईपी को लिया है, मतलब थोड़ा डायरेक्टली।
हाँ,
एसईपी इज इनडायरेक्टली इन्वोक।
and also the fact that if I'm a marketplace like a Amazon or a Flipkart and I don't own, and it's just a marketplace and I'm receiving money,
करेक्ट।
just because I'm not owning those goods, I'm receiving money does not will preclude the obligation of EL. EL फिर भी लगेगा, ये अमेंडमेंट के तहत उन्होंने क्लैरिफाई कर दिया, राइट। Then there was a issue of mismatch of year की जो एग्जेम्पशन थी, वो बात हम फाइनेंस एक्ट 2020 और 2021 की कर रहे थे, तो वो एक साल में क्या डबल टैक्सेशन का एक्सपोजर होगा? तो वो उन्होंने क्लैरिफाई कर दिया कि ये 1 अप्रैल 2020 से एग्जेम्पशन अप्लाई करेगी, 2021 से नहीं करेगी, तो कि वो जो एक साल का 2020 में जब स्कोप इनहैंस हुआ वो एक साल भी कवर हो गया। लेट मी रिपीट इट वन मोर टाइम। द स्कोप ऑफ
two clarification they have made that royalty and FTSA are not excluded, and e-commerce is excluded,
and it relates back to 1st April 2020 because the enhanced definition of EL came in 2020.
No,
So,
this means royalty and FTS prior to 2020 will be doubtful whether it can.
बट वो एकेडमिक हो जाएगा, क्योंकि गर्ग साहब 2020 से पहले ईएल का स्कोप 2016 में सिर्फ वो तीन
था ही नहीं,
कैटेगरीज।
था ही नहीं.
हाँ, और वो कैरेक्टराइज याहू और राइट फ्लोरेस की जजमेंट में वो बिजनेस प्रॉफिट हो गया।
But exemption under 1050 is for equalization levy also, na?
यस,
Uh,
एब्सोल्युटली,
so service royalty and FTS is also a service.
एग्रीड।
उसका
तो
advertisement नहीं है वो. Correct, correct,
हाँ,
correct. Agreed,
ठीक है,
agreed.
ठीक है, नेक्स्ट स्लाइड प्लीज। Now, the comparison between royalty and FTS, if you remember, Garg Sahab was very kind to chair my Section 9 session where we
Hmm.
probably touched upon royalty and FTS. And
Yes,
on
yes.
this very illustrious platform, we have taken through you the Supreme Court decision of the great jurist Justice Nariman in the case of excellence also.
Hmm.
So that aspect is taken care of, but that I understand touches only a limited aspect of computer software, and the scope of royalty is very wide. I
Yes,
think you could look at this slide. This is quite self-explanatory, and in the interest of time, I'll skip because I'm not even half my slides, and we have only 15 minutes remaining.
yes,
Right?
yes.
Yeah, let's move forward. Now, क्या क्या सिचुएशंस हैं और कहाँ कहाँ ईएल की लेवी आ सकती है? आई थिंक पुलकित हैज बीन वेरी काइंड इनफ इन stacking few decisions, and this is a great research piece of slide, although a busy slide. It will rather help you in understanding that why the legislature felt in its wisdom to have an EL, only
Correct.
because of the fact that these transactions were regarded as not being subject to tax for various reasons, चाहे सेल ऑफ सॉफ्टवेयर देखिए आप, या एडवर्टाइजमेंट फी देखिए, या ऑनलाइन डेटा प्रोसेसिंग वगैरह देखिए। ऑफ कोर्स इसमें कॉन्फ्लिक्टिंग डिसीजंस भी हैं, बट so that is why I think to settle the dust you have a separate vertical which is the EL. Next slide please. Similarly, you have these situations of
Broadcasting,
broadcasting
telecom.
service and yeah. Next slide please. हाँ, सो एक केस स्टडी देख लेते हैं। एक फॉरेन वेंडर है जो अपना राइट, कोई इंटेलेक्चुअल प्रॉपर्टी जो है वो किसी सिनेरियोज में इंडियन कस्टमर को राइट देता है। फॉरेन कंपनी इज आउटसाइड इंडिया, इंडियन कस्टमर इज इन इंडिया, एंड व्हाट आर द इश्यूज और क्या सिनेरियोज होंगे अगली स्लाइड में देखते हैं। तो पेमेंट ऑफ एफटीएस अंडर द एक्ट बट नॉट कवर्ड बिकॉज ऑफ द सेकंड सोर्स रूल। एनआर टू एनआर पेमेंट अगर होगा तो कवर नहीं होगा। अगर एनआर टू एनआर पेमेंट है तो ट्रीटी भी नहीं लगेगी। पी नहीं है तो ट्रीटी में ये सिचुएशन नहीं होगी। हम सिनेरियो 1 की बात करें, सारे सिनेरियोज रोज में दिए हुए हैं और डिफरेंट परम्यूटेशन कॉम्बिनेशन कॉलम में है। क्या ईएल अप्लाई हो सकता है? आंसर इज यस। सिमिलरली सेकंड सिनेरियो ये है कि पेमेंट इज रॉयल्टी और एफटीएस अंडर द एक्ट बट एग्जेम्प्ट अंडर द ट्रीटी ऑन अकाउंट ऑफ नैरोअर डेफिनेशन ऑफ ट्रीटी, मेक अवेलेबल या एक्सक्लूजन। डोमेस्टिक टैक्स लॉ में टैक्स होगा, हाँ जी, ट्रीटी में नहीं। पी नहीं है तो आर्टिकल 7 में अट्रैक्ट नहीं होगा। ईएल लग सकता है, बिल्कुल। अब सिचुएशन 2 का वेरिएंट है कि अगर मेरा पी है तो डोमेस्टिक टैक्स लॉ लगेगा, हाँ जी। एफटीएस नहीं लगेगा क्योंकि वो 7 में ले जाएगा बिकॉज इट इज इफेक्टिवली कनेक्टेड टू पी। थर्ड बॉक्स आपका टिक हो गया। ईएल लगेगा, नहीं लगेगा क्योंकि वो पी से कनेक्टेड है। फोर्थ सिचुएशन, पेमेंट इज रॉयल्टी एंड एफटीएस अंडर द एक्ट एज वेल एज इन ट्रीटी। डोमेस्टिक टैक्स लॉ में टैक्स होगा, ट्रीटी में होगा। चूंकि एफटीएस है, पी से कनेक्टेड नहीं है तो फिक्स प्लेस पी और डीटीए का कॉम्बिनेशन नहीं लगेगा। ईएल लगेगा, नहीं लगेगा क्योंकि जो एफटीएस और रॉयल्टी है वो क्लैरिफाई हो गया, उस पर ईएल नहीं लगेगा।
Correct.
अब अगली उसी सिचुएशन का एक और वेरिएंट है कि एफटीएस और जो रॉयल्टी है ये फिक्स प्लेस का जो कनेक्टेड वाला था वो तो हमने ऊपर देख लिया। अब देयर इज अ फिक्स प्लेस ऑफ पी इन इंडिया, सेम फैक्ट्स। ट्रीटी डोमेस्टिक टैक्स लॉ में टैक्स होगा, यस। अंडर ट्रीटी, यस। fixed place PE, so it will get taxed in 7, not under 12 or 13. Will EL apply? The answer is no, because you have got a fixed place of business in India, right? So
Correct.
this is the various permutation combination. Please read the word royal as royalties. My apologies for this little typos, right? Next slide, please. So impact analysis जो अब इतना मुहिम, all that discussion is and the heartburn is on account of the fact that the way you have described these definitions, this applies only not only to e-commerce retailer but also to business which are under brick and mortar, which have some degree of digitization, which was exactly the question of गर्ग साहब कि ये पेमेंट के अलावा बाकी चीजों को लाने की कंसिडरेशन जो कॉन्ट्रैक्ट एक्ट के वेरियस फेसेट्स हैं उसका जरूरत क्या था, वो यही जरूरत था। एक फॉरेन कंपनी है, उसका यहाँ डिस्प्ले आउटलेट है, आपने आउटलेट में जाके देख लिया, अमेजॉन इंटरनेशनल से प्रोडक्ट बना मंगा लिया, पर आप तो कहेंगे कि साहब हमने तो ऑर्डर प्लेस तो जाके किसी अच्छे स्टोर में किया था, सो बी इट, बट चूंकि आपको डिलीवरी ऑनलाइन हुई तो ये है। या उल्टी सिचुएशन ले लीजिए, आपने देखा नेट पे ऑर्डर प्लेस कर दिया, फॉरेन कंपनी ने आपको कहा कि साहब हमारा एक सेंट्रलाइज्ड वेयर हाउस है, वहां से आपको डिलीवरी बाय डिस्पैच हो जाएगी, आप या एक हमने एक नया सिर्फ एक डिस्प्ले आउटलेट खोला है, उस पर आप खरीद नहीं सकते, चीजें जाके देख सकते हैं और अपना डिलीवरी ले सकते हैं, बिकॉज आपने ऑर्डर नेट से दिया था तो भी लग जाएगा, राइट। एक और डाउट जो बहुत मल्टीनेशनल कंपनीज में है कि हमारी इंट्रा ग्रुप ट्रांजैक्शंस का क्या होगा। फॉर इंस्टेंस, you have a ERP, which is a global recognized situation, multinational companies, intergroup companies, you want to place an order, you as part of the big group, you place an order on the online ERP system and the goods get delivered to you. Not just because you have placed the order on the online ERP, which is an intranet, and you get the orders, will that mean that the related party is obligated to pay EL? ऑल बिग मल्टीनेशनल कंपनीज विल टेल यू कि साहब आपको इंपोर्ट चाहिए, माल करना है, कस्टम्स से आ जाएगा, बट आप ईआरपी पे एक ऑर्डर प्लेस कर दीजिए, अपनी रिक्विजिशन डाल दीजिए। दिस इज अ वेरी बिग लाइव इश्यू ऑन ईयर। That what happens to intra group transactions where you are using some bit of digitization, and although in substance they are not provision of services through online medium. So this is a challenge.
Correct.
Next slide, please. So, if you look at some case studies where payments are being made to digital platforms such as booking of hotels, online sale of goods, we have just discussed, delivery concept we have just discussed. The fact that mere booking of a hotel takes place through online can make potentially the transaction subject to equalization levy. आपने होटल बुक कर लिया, ऑनलाइन गए, होटल में रहे, वहीं पेमेंट करी, आपने सिर्फ ऑनलाइन बुक किया, कोई एडवांस नहीं दिया, booking.com पे आप गए, उन्होंने आपका होटल बुक कर लिया, 1 नाइट चार्ज लिया नहीं लिया, आप गए, आप होटल में रुके और वहीं पेमेंट करी, इज इट सब्जेक्ट टू ईएल?
But as per the criteria which you have explained earlier, one transaction is booking is covered by
Yes,
that.
and therefore that is why I've said in the last line of the slide that it can potentially make the transaction subject to EL.
Correct.
Right. Next slide, please. अब मार्केट प्लेस सिचुएशन जो अमेजॉन, फ्लिपकार्ट ऑफ द वर्ल्ड हैं, जो बिग बास्केट्स ऑफ द वर्ल्ड है, वहां डबल टैक्सेशन होने का भी पूरा चांस है। और वो पूरा एक हमने एक आपको एक ट्रांजैक्शन का लाइफ साइकिल एक्सप्लेन किया हुआ है। इन द इंटरेस्ट ऑफ टाइम आई विल स्किप दिस, बट दिस स्लाइड इज क्वाइट सेल्फ एक्सप्लेनेटरी, जस्ट टू टेल यू दैट देयर इज क्वाइट बिट ऑफ चांसेस ऑफ डबल टैक्सेशन।
Amazon का Indian transaction, suppose I am placing an order on Amazon, they are buying from India itself, they are asking somebody
वो
to supply it.
194 में कवर होगा गर्ग साहब,
194 में।
हाँ, इनफैक्ट वो 194 में कवर होगा। एंड इन द इंटरेस्ट ऑफ टाइम आई थिंक लेट्स jump to 194. Let's come to स्लाइड 33 34 प्लीज, बिकॉज कुछ ही मिनट रह गए हैं और मैं उसको कवर कर लेता हूँ. So this is the 194O situation. If you look at this slide, it explains 194 situation where there is a definition of e-commerce, e-commerce operator, e-commerce participant, right? The e-commerce operator will be deemed to be the person responsible to pay to e-commerce participant, and he is therefore person responsible for paying for the purposes of section 204, right? सो अगर आप एक सिंपल सी ट्रांजैक्शन इसमें लेते हैं कि एक ई कॉमर्स ऑपरेटर है जो फैसिलिटेटर है आपका अमेजॉन इंडिया, और इसमें बायर या सर्विस रेसिपिएंट could be anyone amongst us. We place an order and e-commerce operator who is a facilitator, बिग बास्केट या अमेजॉन इंडिया जिसकी आपने बात करी, उसने ई कॉमर्स पार्टिसिपेंट को आगे प्रॉम्प्ट कर दिया, आपने मार्केट प्लेस पे जाके ऑर्डर प्लेस किया, और ई कॉमर्स पार्टिसिपेंट जो वहां पर अपने गुड्स को इन्वेंट्री को डिस्प्ले करता है, वो आपको गुड्स आपके घर पहुंचा देगा या आपको सर्विस रेंडर कर देगा, राइट? अब 1% टीडीएस ग्रॉस अमाउंट का जो पेमेंट जाएगी वो उसको देना पड़ेगा.
नो किस पे, अमेजोन पे लगेगा या
अमेजोन पे e-commerce operator shall be the person responsible for paying to the e-commerce participant. So Amazon is responsible. जो वहां पर Amazon के प्लेटफॉर्म पे जो आपको कोई भी प्रोडक्ट डिस्प्ले कर रहे हैं, किताब कुछ भी मान लीजिए, उसकी जिम्मेदारी नहीं है ये 1%. ये 1% की जिम्मेदारी जो है वो Amazon की है. हाँ, टीडीएस तब नहीं लगेगा जब ई कॉमर्स पार्टिसिपेंट एक इंडिविजुअल या एचयूएफ है and his gross amount of income, gross amount of sale is less than 5 lakhs of rupees, और उसने अपना पैन और आधार ई कॉमर्स ऑपरेटर को दे रखा है. अदरवाइज पेमेंट इज सब्जेक्ट टू अ टीडीएस ऑफ 1%. अब आपका सवाल होगा कि नॉन पैन नॉन आधार केस में क्या होगा? उसमें टीडीएस का रेट हो जाएगा 5% फॉर नॉन पैन एंड नॉन आधार केसेस. Because let's go to next slide please. Yeah, this is the 5% situation. एक्सेप्शन मैंने आपको बता दिया कि नॉन रेजिडेंट के लिए ईएल है, रेजिडेंट के लिए 194O है. सो इफ द ई कॉमर्स प्लेटफॉर्म और द ई कॉमर्स ऑपरेटर इज अ नॉन रेजिडेंट, देन यू विल गो टू EL provisions, and if the e-commerce operator is a resident, then you will come to 194O, and non-resident e-commerce participants are exempt from 194O. 5 lakhs of amount I have already told you, and if there is no PAN, then no Aadhaar, then you are looking at a TDS of 5% instead of 1% under section 206 AA of the Income Tax Act. Right now, in the remaining few minutes, I don't think I'll be able to cover SCP per se today, but Sunil Bhai is telling me that this webathon has attracted so much of traction that that the response is so overwhelming that we need to even continue after our stipulated 7 modules, which I had suggested in one of our concluding sessions when we had that hybrid thing at Hindi Bhavan, that we will do 7 sessions dedicated on some modules of international taxation and white collar crime. But I'm very heartened to share it with you, and maybe Sunil Bhai can speak at length on another occasion, that we are planning some more sessions on some very specific themes which are very topical and very live and burning. So maybe SCP as a whole, I can take it up in one of those themes. And for the time being, to conclude in the remaining few minutes, let me just take you through one case study or 2 case studies. Let's look at this case study of making a booking through a e-commerce platform. Let's talk of a make my trip sort of a situation, right? Next slide, please. So let's say Mr. S books an online ticket on a portal which charges airfare, including GST, service charges, etc. The invoices provide details of the airfare charge और एक breakup आ जाता है जिसमें ये breakup दिया गया है, right? Now, e-commerce participant would be an airline company as it is selling its tickets to the portal, which could be Make My Trip or Travel Yatra or Yatra.com or whatever it is. E-commerce operator, the facilitator here is Make My Trip as it provides the facility. 194 will get invoked because this Make My Trip is providing e-commerce facility. TDS will be deducted by Make My Trip on total fare payable to the airline, and airline is again not subject to deduct TDS on the services provided by Make My Trip. This is how the whole arithmetic would work in such a situation. Now, what is the interplay between EQ, equalization levy, and 194O? Let's look at this slide and then we'll do one more case study.
Yes.
Yeah, next slide, please. So, who is liable to deduct under 194O? It is the e-commerce operator. Equalization levy, e-commerce operator is liable to deposit the levy with government. Residential status, resident, non-resident, non-resident. Residential status of e-commerce participant, resident. Customer can be both resident or non-resident in both situations. वहाँ 1% है और वहाँ 2% है. Right? Of course, वो 6 भी हो सकती है depending on the nature of.
This Amazon, etc., how much they get from the dealer, supplier? Hello? Some problem there.
Yeah, my apologies. I think we had a
Some problem is there.
yeah. So let's come to the last case study for the day, which is slide 37.
No, what
So
I was
let's look
asking,
at-
how much Amazon is collecting from the supplier? Because they have to pay 1% as tax levy. Then how
Anji,
much they are collecting? More
I
10%?
don't have the. You want the exact absolute rupee value में कितना collect कर पा रहे
No,
हैं?
no, percentage wise. Suppose
1%.
X is
Amazon
supplying
India 1%.
10%.
1%. 1%.
No, 1% is the tax. But how much they are?
1% is the TDS.
That is TDS.
हाँ जी.
But from the supplier, how much they are earning?
Oh, trust me, my friends and clients who are just getting onto the marketplace space, they are saying कि हम काम ही उन लोगों के लिए कर रहे हैं.
अच्छा.
Their commissions are very, very high. I mean, Garg Sahab, unless and until you are making big volumes, actually the premium is so high and the contracts are very, very tough. I mean, as a contract lawyer, I can tell you, for initial few years, unless and until you have a great brand recognition, it is very tough to be able to come to commercially justify these because you are actually paying very high amounts of commissions.
Yeah.
Yeah. Now let us look at one last case study before I hand it over to Senior Garg Sahab for his concluding remarks. Let us look at this transaction. So there is a hospitality service and there is a customer who books a room online, booking.com or You can imagine anything. And there is a non-resident e-commerce operator. Now, two, and let's say the amount paid is 10,000 rupees. The facilitation fee which is charged by the operator, जैसे भी गर्ग साहब ने पूछा वो कितना कमाते हैं, let's say इस केस में वो 500 रुपये है, right? And then there is a resident e-commerce participant जिसका वो होटल है. So आपने दिल्ली में रह के एक बॉम्बे में होटल बुक किया और उसके लिए जो आपने मार्केट प्लेस या प्लेटफॉर्म ढूंढा वो एक नॉन रेजिडेंट या एक फॉरेन प्लेटफॉर्म था. लेट्स से booking.com is a foreign platform or a Airbnb is a foreign platform. So in a way you've taken services of a non-resident e-commerce operator of making a booking, let's say of Taj Mansingh or Taj Mahal Mumbai, right? And if you look at the margin which is 500, now the question is whether the equalization levy will be paid on the entire 10,000 rupees on the facilitation fee, which actually is the real margin of that booking.com or that airbnb.com. Second question which arises, would TDS will also apply under 194 at the rate of 1%? Right. So these are some implications of potential double levy, double taxation. Not double taxation in its true sense, but yes, double levy of immediate withholding tax. Although EL is a final tax, so to speak, so there is a double incidence of taxation.
194O applies only when it is in income. It is excluded from income.
Right.
So therefore 194O will question of application will not arise, na?
उसकी एक बार आप गर्ग साहब एक्सप्लेनेशन पढ़ें. जो 194 ओ का सबसेक्शन 1 की एक्सप्लेनेशन है, उससे ऐसा एक डाउट क्रिएट होता है कि जो 10,000 रुपए मैंने दिए booking.com को, जिसमें से उसने 500 रुपए रख के 9,500 रुपए का मार्जिन दे दिया उसको ताज मानसिंह होटल को, क्या 194 ओ का भी एक्सपोजर होगा? ये एक देखने वाला.
That's what I am saying. 194O का exposure होगा when it is income. It is excluded from income by 1050. Once it is excluded from income, then 194O will not apply.
Agreed, Garg sir, but that 1050 is qua EL payment made to e-commerce operator. Here, the hotel is the e-commerce participant.
Oh, अच्छा अच्छा.
भाई ताजमहल होटल को तो जो प्राप्ति हुई और मैंने जो booking.com को दिया वो दो डिफरेंट ट्रांजैक्शन है ना. Yeah. Now Aditi has a question. As an individual buy something from Amazon, this transaction on EL would apply. B2C नहीं है. Thankfully there is no B2C. So that's the answer to Aditi. So Garg sahab, with this I will hand it over to you. Akanksha, PPT will come through good offices of Mr. Chawla and Sunil Bhai. Don't worry on the PPT. It's a good material and you'll. I'm sure it will be of useful reference. With this, Garg sahab, I hand it over to you for your closing remarks.
Mr. Chawla has explained the difficult provisions in a very nice way, and with some bottlenecks which are still yet to be resolved, either by courts or by clarification by the board. But so far as the provisions as they stand, I think he has explained it in a very lucid manner, explaining what equalization levy is, what the second equalization levy is, then this MES is there. So everything, I think he is very, very nicely and very, very ably, which be it this, I said in the beginning that even OECD could not resolve that problem. He had tried to some extent resolve it in a very lucid manner and an effective manner rather. And thank you very much.
Thank you.
Yes, sir.
Thank you, sir.
God bless you.
Thank you, sir. Your turn.